Hello, this is Kristin Rosan, and I am an attorney with Madison and Rosan, and I'm here today to talk about House Bill 532. I've put together a presentation for you on the summary and practice tips for the implementation of the new legislation. First slide we'll take a look at is a table of contents. This is the different areas that we're going to be talking about today with respect to House Bill 532. We'll look at introduction and history, brokerage trade names, principal brokers, management level licensees, associate brokers, earnest money, contemporaneous offers, and disciplinary sanctions and next steps. Moving to the next slide, House Bill 532 is the first significant update to Ohio real estate license law in a decade. It was signed by Governor Kasich on January 4th, 2017, just earlier this month, and will become law April 4th, 2017, in essence 90 days. Now, unfortunately, the Superintendent of Real Estate and the Real Estate Commission won't have sufficient time to engage in rulemaking between now and the effective date of the legislation, so it's critically important to understand what the law provides and then, of course, what we expect the rulemaking to provide, and we'll go through some of that today. The new law will impact how brokerages and salespersons practice daily, and again, the Division of Real Estate will engage in rulemaking to implement the new law. The other thing we expect in advance of the rulemaking is some policy decisions from the superintendent in terms of how brokers and agents are to practice in the interim period between when the law becomes effective and when the rulemaking ultimately becomes law. The legislation is a result of recommendations from the Ohio Real Estate Commission. They had a license structure review task force. The new law also clarifies information that was supported by the real estate industry. It was introduced by Representative Ryan Smith in April of 2016. It made it through both houses of the House and the Senate, and then, of course, as I mentioned earlier, was signed by Governor Kasich earlier this year. So the first area we're going to talk about, the next slide, is brokerage trade names. This is the first major area that you will see changes in with respect to the new law. It permits a brokerage to apply for and use more than one trade name. Superintendent always has the ability to maintain approval of a brokerage's name, and the superintendent can deny a name if it is misleading to the public or if it is not distinguishable from an existing brokerage. So let's talk a little bit about this slide just for a moment. In the process of obtaining or setting up a new brokerage, the first thing that a broker does is they file a name approval application with the Superintendent of Real Estate. She has the sole ability to regulate and approve or deny the naming of real estate brokerages. This is even though the name might be available through the Secretary of State's office. It doesn't matter. You have to get approval from the Superintendent of Real Estate first. And one of the things that she's going to be looking at is whether or not the name is likely to mislead the public or whether it's distinguishable from an existing brokerage. The law, one of the changes in the law, allows a brokerage to use more than one trade name. So I think where this comes into play is you might have a corporate brokerage that has offices in different areas of the state. And so, we might call it Kristin Real Estate Inc., and Kristin Real Estate Inc. might have a brokerage in Cincinnati, which is called Southern Ohio Real Estate, and we might have another brokerage in Cleveland, which is Northern Ohio Real Estate, but it's one company. It's just operating under two different names. And so what this does is it allows the superintendent to approve a singular brokerage entity utilizing two different names for that real estate brokerage. Now, the law does provide that if you obtain those DBA names or trade names, that the brokerage then has to practice under those names. It can't practice under any other name. So the next slide on brokerage trade names, superintendent must approve the application for a name in a case where the name is not clearly distinguishable from a name that's already registered by a brokerage. The existing brokerage provides written consent to the brokerage requesting the name. And in essence, what this means is that If you've got Kristin Real Estate in Columbus and Kristin Realty in Dayton, she may say that the name is not readily distinguishable from the Dayton brokerage, and so she might deny my application to get the Columbus brokerage named Kristin Realty. So if I were to go to the Dayton brokerage and get approval from that entity or the broker that owns that name, this allows the superintendent to go ahead and allow me to have a name that is not readily distinguishable. There is, of course, a caveat, which is that the name still can't be misleading or likely to mislead the public. So she still has the ability to exercise some discretion, even when you have written consent from a brokerage that has a similar name to the one that you're looking to use. Next slide. So this is our next major topic, and this is about principal brokers. This is a very new structure for the structuring of a real estate brokerage. Under current law, every broker that is affiliated with a brokerage is equally responsible for the day-to-day functioning of a brokerage. And so many times you'll see in some brokerages, folks will have their broker's licenses, but they'll put them on deposit and have a sales license because they don't want to be responsible for the functioning of the brokerage. There's also not clarity in terms of who is responsible for the running of the brokerage and who the state or who other agents would need to contact to talk about who is responsible for the agents, the policies, or issues that may come up with respect to that particular brokerage. And so what has been designed is a scheme that identifies a principal broker, a management level licensee, and an affiliated broker, or it's called, in essence, associate broker is actually the correct terminology. So let's start first at principal broker. Principal broker is defined as a licensed real estate broker that oversees and directs the daily operations of the brokerage. So each brokerage must have at least one affiliated broker designated as the brokerage's principal broker. Now, in some brokerages, this may be the only broker, in which case the singular broker is going to be that firm's principal broker. But some of the larger brokerages that have multiple licensees that are brokers, then one of those persons will be designated internally. It's entirely the broker's own decision as to who that person will be, but they have to report to the superintendent of real estate who that brokerage's principal broker is. And then, of course, if there's any change in the principal broker, notice must be given to the superintendent within 15 days. So, for example, if the principal broker passes away or if he or she affiliates with another brokerage, any change, or let's just say takes on additional duties or responsibilities or a different role within the brokerage, any change in the designation of who is to be that firm's principal broker has to be notified to the superintendent of real estate. Principal broker, this is another really big change. Principal broker may be affiliated with more than one brokerage at a time. And we see sometimes where, for business reasons, tax reasons, whatever the case may be, that there are brokerages that are different corporate entities, but they have same or similar ownership structures. And that might be where a circumstance where I foresee a principal broker being affiliated with two separate brokerages. And we'll get into some of the responsibilities of the principal broker. And of course, the principal broker will have to make a decision as to whether or not they're able to sustain those responsibilities for more than one brokerage. Next slide, we're going to be talking about the principal broker's duties. So this is the first time where we have seen prescribed in license law specific duties that are assigned to a particular type of licensee. So this is a really big and dynamic change for how these brokerages operate. So the principal duty of a broker is to oversee and direct brokerage operations, comply with the requirements to have a definite place of business in Ohio, has to display the license in the office and the branch offices if applicable, and have a sign on the business premises plainly stating that the licensee is a real estate broker. These are requirements typically assigned to the brokerage, and they are being assigned now specifically to the principal broker. Next, continuing to talk about duties, every broker's office has to prominently display the state's or real estate commission's fair housing pamphlet. If you don't know where that is, it can be obtained by going to the Division of Real Estate's website. They have a copy of it there on their website, the pamphlet that you're supposed to display in the office. The principal broker is to timely renew the brokerage and branch office licenses, and then has to maintain all the salespersons' licenses in a way that they can be made available upon request. And I will tell you, when the superintendent of real estate sends her investigators out to conduct a brokerage audit, one of the things that they will ask for is to see the salesperson's licenses. And I think it is a worthy exercise for an office manager or administrative staff or even the principal broker to periodically review the hard copy licenses that the brokerage has on hand and compare those with the list on the Division of Real Estate's online licensure database. So what I mean is that you would go to the Division of Real Estate's website and you would pull up your brokerage. So Kristin Rosan Realty, and it's going to list, I've got a medium-sized brokerage, maybe 10 different agents that are affiliated with me. You want to compare that list with the number of licenses and the names on the licenses that you have in your file. Because oftentimes I see in audits, there are old licenses in the file, licenses that haven't been sent back, people that are affiliated with the brokerage that the broker doesn't really realize. Sometimes they agree to hold licenses. So, at least quarterly, I think it is a good business practice to make sure that you're reviewing the files and make sure that your list of licensees in your file is consistent with what's on the Division of Real Estate's records. Make sure, next slide, the principal brokers are required to make sure the brokerage complies with all requirements to maintain a trust or special account, including property management trust accounts if applicable. So we all know that the brokerage maintains an operating account. The brokerage also is required to maintain a trust or special account. I'll just briefly tell you that the trust and special account needs to have the principal broker as a signatory on it. The account on the checks, the account itself, and deposit slips has to have the name of the brokerage as well as the words trust or special account. And then, of course, the brokerage trust account cannot be interest bearing. Brokerages are permitted to maintain a small amount of money in the trust account to cover monthly fees. Other than that, every record of a transaction of money coming in and money going out has to be maintained by the brokerage. And then, of course, there are additional requirements if the brokerage maintains a property management practice, in which case there would be a separate property management trust account if the brokerage maintains funds in that practice in a fiduciary capacity. They have to maintain complete and accurate records of all transactions and trust account records. That means all of the transaction files. The broker needs to make sure there's a mechanism for keeping transaction files, and then, of course, making sure that ledgers, trust account ledgers, are maintained as well. Maintaining up-to-date company policy and consumer guide to agency relationships. So the company policy, it used to be called the long form company policy. This is it can be anywhere from 20 to 30 pages, and it goes through the brokerage's duties of confidentiality, what happens when an agent is handling their own transaction, identifies the management level licensees for the brokerage. It has a number of nuggets of information that I think are superb for new agents to go through. The broker would be required to make sure that the company policy is up to date, and you can take your there is a particular statute that outlines what is required to be in the company policy, and so that would be something that you would probably want to review on an annual basis. And then, of course, your consumer guide to agency relationships. Oftentimes I see consumer guides are printed out and not changed, and one thing to be aware of is periodic changes in the fair housing law will change your consumer guide to agency relationships. So it's not a bad idea, at least annually, to take a look. Consumer guides samples are on the Division of Real Estate's website. Take a look, make sure that your consumer guide is up to date. Next slide. It is the obligation of the principal broker to make sure that agents are paid commissions within a reasonable time after they are received by the commission. There is also a caveat that a broker may send an accounting. So, for example, if the salesperson owes the brokerage money, then an accounting would be provided, and then, of course, the earned share of the commission has to be paid to the salesperson. The principal broker has to establish practices to assure the brokerage is not suborning unlicensed activity, and that's a fancy way of saying paying real estate commissions to folks that are not licensed as real estate licensees. There is the ability, and there has been for some years now, for a real estate brokerage to pay a commission to an entity that is owned by the affiliated licensee that earned the commission. So, for example, Kristin Rosan, real estate agent, I have my own LLC, Kristin Rosan LLC. I could ask my broker to pay my money, my commission, to my LLC instead of to me personally. And there are a number of reasons why agents elect to have their commissions paid in that manner. If a brokerage does decide to forward an agent's commission to their affiliated limited liability company or whatever entity it may be, there are a set of statutory requirements that have to be followed, and so you'll want to make sure that as a principal broker you're making those payments in accordance with those provisions. On the next slide, there is a requirement that the principal broker oversee licensed activity of agents to make sure they're providing services with their area of competency or working with another competent agent. Now, this is a new provision. There's not anything that is like kind in prior law. And in essence, it's saying if a real estate agent isn't competent in a particular practice area, the principal broker can be responsible for allowing that agent to practice and presumably commit malpractice because they're not competent in that particular area. And so the only exception would be if that agent is paired up with a competent agent to engage in the practice. So a perfect, I think, obvious example would be a residential real estate agent wants to engage in a commercial transaction. They've never handled a commercial transaction before. The principal broker can be culpable or responsible if he or she allows that agent to engage in a commercial transaction without the assistance of another competent commercial real estate agent. Practicing within your area of competency is receiving special attention, and efforts made to make sure that the principal broker aligns new agents or agents that aren't competent in an area with those that are competent so that mistakes aren't made in a transaction. Principal broker is allowed to assign any of their duties to a management level licensee, and we'll talk about that next. The next slide is your question is going to be, well, gee, Kristin, that's great, but what is a management level licensee? So a management level licensee is a licensed real estate agent, broker, or salesperson. They are affiliated with a brokerage. They have supervisory responsibility over other licensed brokers or salespersons affiliated with the brokerage, and they are designated in the brokerage's company policy. So where I could see, this is not new law. What they did is they took it out of the agency section of the law and they put it in the definition section. And there are some additional roles for management level licensees in the law, and so that's why we're talking about them in the context of the pyramid being principal broker at the top, management level licensee next, and then of course the associate broker next in line. So the management level licensee I foresee being kind of like your office manager. So you might have a large brokerage with a number of branch offices, and I could foresee a principal broker assigning management level licensees in the branch offices responsibilities to make sure that all of those duties that the principal broker is supposed to be carrying out are indeed carried out within the respective branch offices. The next section we have here, next slide, is the associate broker. So this is the third one. We've talked first about the principal broker, then we talked about management level licensees, and then the third is the associate broker. So the associate broker is a licensed real estate broker with the brokerage. Now, one thing, I don't know if you caught it, But one thing that is interesting is that you've got the principal brokers, and they can assign their duties to a management level licensee, but a management level licensee doesn't necessarily have to be a broker. It could be a salesperson. It is a salesperson or a broker that has supervisory responsibilities. So, and then of course you go to associate broker, which of course is a person that is only licensed as a broker. The definition is that they do not function as a principal broker or a management level licensee. So they might have a broker's license, but they don't have any supervisory responsibility. After the brokerage designates the principal broker and all other affiliate brokers are either the management level licensee or an associate broker. So principal broker and then anybody else is going to fall into one of the two categories, either a management level licensee or an associate broker. I think the way to think of an associate broker is somebody that has a broker's license but otherwise just practices like an agent or salesperson. So that is the new structure of how brokerages are going to be handling brokers, management level licensees, and then of course the associate brokers. What's going to be interesting to see in the rulemaking is, as we start to implement this structure, how it impacts, for example, will it make changes to the consumer guide to agency relationships? Will these different levels be disclosed there? Will it implement changes to the agency disclosure statement? We know we have provisions that all brokers or management level licensees are dual agents on in-company transactions, and will that continue to be the case? So there are some unanswered questions at this point, and I think we'll be looking for some guidance, and we expect to receive guidance from the superintendent and the commission in the coming weeks and months. And then, of course, we'll talk about the rulemaking efforts underway, which would, in essence, put into law some of these questions that are coming up as a result of the new legislation. So the next major topic area that we'll talk about is earnest money. And I want to give you a little bit of background as to why this became an issue that made its way into this legislation. So a number of purchase contracts around the state have language in them, and if you look at purchase contracts that you utilize, you'll see there's language that says that upon the occurrence of a particular contingency, or if there's a termination of the purchase contract, it's, quote, the earnest money shall be returned to the buyer, or the earnest money shall be dispersed to the seller. And there was a legal theory out there that the broker is required to hold the earnest money until they receive written instruction from the clients, signed by both parties, as to how it should be dispersed. And so the argument was, well, because it has to be dispersed in accordance with the written instruction, and you've got a written instruction in the signed purchase agreement, that written instruction is sufficient. So you had a theory that there didn't need to be a separate signed mutual release in order for a broker to release earnest money to one party or the other. And so in order to clarify that point, the new law requires a separate written instruction between the buyer and the seller on the dispersal of the earnest money. So in essence, what this does is really a cleanup measure. Most everybody in practice requires a termination, and they require a mutual release to be signed in order for earnest money to be released. And in essence, what this is saying is you cannot any longer rely on the purchase contract itself to accomplish that. Rather, there has to be a separate signed writing between the buyer and the seller directing to whom the earnest money has to be released. Next slide, contemporaneous offers. This was another cleanup measure. This was kind of a little bit of an ambiguity in the law, and I think it came about because in the last few years we've had such a strong seller's market. There's been such high competition for housing, and some issues have come up as to whether or not there's any type of breach of ethics in certain circumstances. And so the contemporaneous offers provision of the law is really meant to address that. So I wanted to give you a little bit of background before we talk about how the law has changed. First, the current law provides that real estate licensee does not breach any duty or obligation to a purchaser by showing the same property to other purchasers. So I guess put simply, if I'm a buyer's agent and I show one of my buyer clients a property, and then I have another buyer client that's interested in the same property, I don't breach a duty to buyer number one by showing buyer number two the same property. But and there's always a but, the canons of ethics, which is promulgated by the Real Estate Commission, provides that a licensee should not enter into an agency relationship with a party whose interests are in conflict with those of the licensee or another client represented by the licensee. So what the ethics provision says is, the interests of buyer 2 might conflict with the interests of buyer 1, and so consequently I should not enter into that particular agency relationship. So you see where there is a problem between those two provisions. So here is how contemporaneous offers was really developed, and it is contained in the law to address that scenario. It's defined in the law as a circumstance where 2 or more clients of a licensee submit an offer on the same property that would be considered by the seller at the same time. So you got 2 or more, you've got submitting an offer, and they're going to be considered at the same time. The new law requires the licensee to provide written notification of the situation to your buyer clients before preparing the offers. So, buyer's agents, beware. When you end up in this situation, we've got 2 buyer clients that are interested in the same property. You're going to have to be very cognizant of the fact that one or both of them may be interested in presenting offers. And before you can prepare offers on behalf of those clients, you're required to provide them notice, written notice, that you represent a competing buyer. Now, moving on to the next slide, the new law does not require you to disclose the identity of your buyer or the amount of your buyer's offer, as that information remains confidential information. So the amount that buyer number 1 is offering is that buyer number 1's confidential information, and you're precluded from disclosing it. And of course, buyer number 2 has the same confidentiality, and so you would be precluded from disclosing any details of buyer number 2's offer to buyer number 1. You would merely be disclosing the fact that you are representing a competing buyer on the same property at the same time, and you do not breach any duty of confidentiality to your clients to tell them that you're representing a competing buyer. Moving next to the next slide, disciplinary sanctions. So we didn't see a lot of additions to disciplinary sanctions in this legislation. There's really only 3, and they make sense in terms of the context of the underlying changes that we have with the legislation. So these are items that if you violate them, the superintendent can charge you with a violation and the commission can sanction your license. So the first is having acted as a broker without authority. So that's a salesperson taking on the duties as of a broker or a management level licensee, and engaging in those activities that are really, I would say, outlined in the duties of a principal broker. Impeding the ability of a principal broker to perform any duties. So if somebody is interfering with the principal broker's management of the brokerage, all of the duties that are listed there for the principal broker, if any individual impedes the ability of the broker to practice, then of course there could be a charge and subsequent sanction for that conduct. And then of course the same thing would then apply for a management level licensee, impeding the ability of a management level licensee to perform his or her duties. So same type of wrongdoing, just depends on who you're impeding, whether or not it's the principal broker or the management level licensee. So the last slide we have here is rulemaking. I talked about this briefly in the beginning. In the coming months, the Superintendent of Real Estate and the Real Estate Commission will undertake rulemaking to implement House Bill 532. I put in the PowerPoint presentation a link to the Register of Ohio. That is the entity or the website that you go to look at the rulemaking if you're interested in seeing what the proposed rules are. You'll navigate to section 1301, which is the Department of Commerce, and then you'll scroll down to the Division of Real Estate's rules. Public for anybody to look at and scrutinize, and of course the Division of Real Estate's required to have public hearings as well, and you're more than welcome to attend those public hearings and even provide testimony if you so choose. And then of course we expect the superintendent to issue some temporary policies pending finalization of the rulemaking process. Final slide, for up-to-date information on House Bill 532 and its implementation, please feel free to visit my blog. It's located in the alumni section of the hondros.com website. Thank you very much for tuning in today, and we hope to talk to you again soon.